moment of time and cherished memories that we are hosting today at IMA Nanded. Law, order, doctor, and everything at one place, which is going to give a complete solution. So, जसं एक आनंदी आनंदकडे इकडे तिकडे चोहूकडे, this is the feeling we have, and with the immense pleasure, ladies and gentlemen, today we have an immense guest, SP Nanded, Avinash Kumarji. We have advocate, we have the senior retired judge, we have the esteemed doctors in this panel. Now, looking at the Dr. Ganesh Shemai, who is a senior doctor and advisor, everybody has been blessed with his talk, and we cherish the memories, sir. You go on talking and we go on listening. But still, at the end of the day and end of this conference, everybody has a feeling that whatever Grace has said, भय इथे संपत नाही, तू शिकवत राहा संध्याकाळी. अशा प्रकारची एक फिलिंग आहे की तुम्ही कितीही सांगितलं तरी एव्हरी पेशंट इज अ डिफरंट अँड एव्हरी मेडिको लिगल aspect is a challenge. So with this kind remark, I will hand over the mic to Dr. Kadam sir for introducing the guest of the evening. Introduction and from city.
Appear before police station. You have to appear before the police authority who has summoned you. वहाँ पे जाके वहाँ after going, what they want to, what information they want from you, it is to be delivered. It is to be told to them.
But what about now the primary feeling of a doctor when he receives such summons or a letter from a police station that I will be behind the bars? That is what. So what safety measures we expect? Suppose I come to you, or suppose I call Dr. Shenoy as an advocate. So what should be the next emotional satisfaction so that I am safe, I am not directly a culprit of the event?
No, if you are not directly involved in the incidents, and already sir has told you that if you are not involved, but some informations you may have, that information is to be given to authorities.
Okay.
Authority, that is police, is a investigating agency, and medical negligence or medical legal, this ambit and ambience of medical legal is very vast. Whether negligence is there or not, that is to be find out.
Okay.
And
Like
if you are
what?
not done it, don't come.
Any other answer from Utture sir in such situation?
Once the police summons you, you have to go. There is no other way out.
Like before that, we will go there, no doubt.
Only thing is, see, you already know there is a death cost. Once there is a death cost, there can be chances that some action is going to be taken. So I think the best part at that time is whoever is your lawyer on record, it's better if you can request him to go with you plus one family member. Don't go alone. Don't go alone. Go with one of your family members and your lawyer. I think that would be a better bet for your safety than trying to go there. That would help. Even I am, because sir has opened up sort of a Pandora's box, and this is a question to both Judge Saab and SP Saab. You spoke about mens rea, right? Now, any death, medical death, is an accident because there is no intention of that doctor ever to kill that patient. So if you go with that thinking, I think any of these death, of course, unless there is some gross negligence of omission, commission, whatever, but accidental death, if there is no mens rea, can we really put, because what the judiciary and even what the police say is that if there is a death, this is going to be a criminal offense. So is every death a criminal offense, or you are going to accept that mens rea concept is there and that doctor is not responsible for that?
For the last 16 years. I am actually not trying to waste your time, but we are very much interested in this topic. So both of us have traveled all the way from Nasik to learn from all of you. And it's a very special event for all of us. Now actually I will just say, सब कुछ सीखा हमने इन 2 दिनों में. अब सीखनी है होशियारी. So this panel discussion for us.
I'm Dr. Shilpa Dayanan. I'm General Surgeon and I have been working with Nasik Municipal Corporation in various capacity, starting from Casualty Medical Officer to Medical Superintendent to Assistant Medical Officer of Health to City Tuberculosis Officer to handling the Divyanga department to all the spices of corporation and the law I have been through. But as it was a fantastic 2 days thing, and actually we are looking forward for more. Thank you very much for giving this opportunity.
Thank you, madam. Myself, Dr. Rahul Lavekar, a pediatric surgeon as well as secretary I am in Nanded. I think this is the epitome of this conference, the most interesting session of interaction with police, judges, and advocate to gain and understand the knowledge and fallacies and intricacies of the day-to-day life. Thank you.
How many of you are by choice attending this session? Sincere and honest hands up. Very nice, very good. And how many of you are here out of compulsion that I should know this subject? To know the subject and the laws. So on the same note, my first question which we practically faced to Dr. Shinoy sir, in my hospital or whatever premises I'm working, I advise for an injection and the sister goes and gives it. And suppose it is a wrong injection she has given. Or I can also say the pharmacist in my hospital has dispensed a wrong drug. How much I am involved and how should I deal with this?
Dr. Anjali. Now, the panelists who are contributing to this session are the great ones in the state, in the medical field, and in the administrative field. I first want to introduce Dr. Mr. Vijay Sikhi sir. He is a retired judge and he is having vast knowledge in the medical field, and all the cases related to the medical field has been attended and has been delivered by him. Mrs. Avinash Kumar is a radiologist, and therefore we are having every right to call him here. Yeah. And we all know Dr. Shivkumar Utture, who is a very well-known personality in the field of law as Medical Council, National Medical Commission, and Indian Medical Association is concerned. We are having a senior lawyer, Mr. Jagirdar, who is an advocate, especially in the field of these medical cases and all. We just listened to him, and he is continuously working being a doctor, and he has delivered a very nice lecture. Therefore, the panelists, they are very good in this panel. The purpose is that the teaching in the form of taking lecture and it in the terms of theoretical discussion, but the panel discussion is that it gives an opportunity to the panelists as well as to the moderators and the listeners to ask the questions of their mind and get the answers from the panelists. Therefore, I welcome all these panelists who have traveled from corner of Maharashtra here to talk with you all. Thank you, Anjali.
So with this, I will hand over to Dr. Shilpa and Navika. Please.
False. Even in many cases, we provide a final to FIRs, where we say we are not able to gather evidence, so we are a finaling the case. So my point is, even if in worst cases, even if the FIR has been done, and if your record keeping, your practices are proper, there is no need to fear. In any case, as we discussed, the chances of arrest has been lower down. अभी तो हम लोग ऐसा हो गया criminals को arrest नहीं कर पाते. Exactly, this is the actual in many cases, because of courts they have said where the punishment is less than 7 years. In such cases, we should not ideally arrest the accused. इसलिए आपको लगता होगा कि चैन स्नैचिंग वाले ये इतने क्यों घूमते रहते? हम अरेस्ट करते वो छूट जाते या उनको बेल हो जाता. In smaller cases, we cannot arrest them. We generally give them notices. So my point is, there is no need to become very apprehensive or fearful of FIRs. Even if FIRs has been done, there are checks and balances, there are safeguards built in the system itself where the doctors will be protected. And in such cases, police also understand that the case involves professionals and there is no need to arrest them. If they are cooperating in the investigation, they are providing all the documents are proper, we try to close the case and we'll do it.
Expert opinion.
Every criminal case is to be decided on the basis of evidence. It can be primary evidence, it can be secondary evidence. It can be oral evidence as well as it can be documentary evidence. What sort of offence is there? If offence is related to the forgery of the documents or cheating based on the documents, then documents will play the primary role in that. If a investigation is in respect of the trial is in respect of the happening of a particular offence, wherein the evidence of the eyewitnesses is material who have seen the crime happening, then in that case, the evidence which has come before the court regarding the mode and manner of the happening of the incident, that will prevail over other aspects. So, in each case, it depends what is the nature of the case, how the evidence is collected, nature of the crime, and thereafter, considering all aspects and material placed on the record, the evidence is to be ascertained and thereafter it is to be scrutinized.
In the same respect, is there any fast track possible for the doctors? Because it is not the thing whether I will be arrested or not. It is the mental trauma through which we are going through this process. So, is there any process of fast track for the?
There is no separate procedure provided for the any specific case. But if a case is serious or if it needs expeditious hearing, then request can be made in that regard. And if the aspects are considered, the matter can be taken up for the hearing earliest.
Sir, my Utture sir, SP sir, and Jay sir is that some emergent not good. The patient is admitted for 3 days. They are not paid a single penny. Patient is non-emergency, and the patient there he is not paying. How the doctor should proceed for the further treatment? Is there any provision to inform it to the police or district administration, or can the patient should be transferred through district admission to the government hospital and doctor can be saved? I'm talking about non-emergency patient.
Yeah, I think in my talk I had already touched upon this point. It is coming in the new code of ethics which is India. In the new code of ethics, it is specifically written that if the patient does not pay you whatever your charges are as per the norms, then you have got a right to jot it down on the endo paper, send it to the local administration, and then transfer the patient to the government hospitals. But as of today, we are under 2002, in which this is not being mentioned. So you will have to wait to transfer this patient to the new code from
As far as police is concerned, non-payment of fee does not come under our purview. It's a kind of civil contract that you have entered into to give some service, and the payment has to be done. But non-payment of service as such, when the patient is already in hospital getting the service, does not come under the purview of police.
That is the practical problem. The patient is admitted without taking fees or monetary return in advance from him. If he is not paying later on, then some civil liability may arise. That can be done by way of recovering the amount. But the patient, if want to be transferred, that can be transferred because he is not.
Sir, my question is, since last 2 days, the importance of consent and documentation is so important, is been told. But practically now it feels that consent cannot be severe than the disease. Like we should not be trapped medico-legally, so we are asked to take such a long consent. So my question is, there was a case in our hospital wherein there was a young boy who came with brachial artery injury, and we had to operate. There were no relatives, so we went ahead and we did we repaired his artery, and everything went fine. But if there is nobody to give consent, then how to proceed? Is there any other law for it, or how much doctor can be in the suit if in such conditions?
I think that is also very clear as far as the code of medical ethics is concerned. If it is a life-saving or a limb-saving surgery, and there is no relative to give you consent or anything, and the patient cannot give you the consent, you can definitely go ahead and operate on that patient. To be completely on the safe side, I think in my lecture also I said that
you take the signature of another doctor of that same field, whoever your colleague is, stating this is, just like how in gynec they do that. So you can do that much. That is an extra safety. It is not a must, but it's an extra safety. But if it is instead, if it is a life or limb saving and you do not do something for the patient, you will be hurt. It's the other way around. So you have to do it if it's a life saving. And this is the situation.
Sir, and another question is, in this era of artificial intelligence, if some complications do happen, who is to be blamed? The doctor, the robot, or the software company, or who?
Pertinent. And just 2 days back, I was in Pune. The Symbiosis Law University has been given by the central government to formulate rules, regulations as far as AI in healthcare is concerned. And we had a full day's discussion. We have come out with some points. And as of today, there is nothing governing AI in healthcare under any law, act, anything. Okay, but definitely these rules, regulations are coming, not in the immediate future, because AI is also in a very nascent state. Today, we also don't understand how much the AI can do, cannot do, and everything. But those laws are coming. The only law is data protection law as far as AI is concerned, which is in place as of today. But as far as AI is concerned, what you're saying is right. Suppose a patient comes to me with the symptoms, I go onto AI platform. The AI platform says that this is appendicitis, but my clinical judgment says this is a tonsillitis. Now, who is right and who is wrong? Suppose I go according to my judgment and it turns out to be appendicitis, I may be in soup. If I follow AI and it turns out that it's a normal appendix which I have removed, then I am in soup. So yes, these rules regulations will be in place, but as of today, it is not in place. Therefore, as of today, you get precedence over AI as a clinician, and you will be responsible for whatever actions you have taken.
Sir, my last. For Utture sir and sir. Sir, there are different decisions by different medical boards. One medical board gives clean sheet to the doctor, second makes him accused, third gives clean sheet. How to proceed?
As a judge. Yeah, I think this has happened.
Yeah, that's why.
And the same thing happens in any other judiciary case also. In CPA it happens so commonly. The state council gives you that the doctor is negligent. Then you go in, the district council, you go to the state council, they say no, the doctor is not negligent. Then the patient goes to the national council and says it is negligent. Boards, yeah. So same thing happens over here. Also, unfortunately, whatever as far as the judiciary is concerned, Bolam's test used to be what up till even today, I think you all are following the Bolam's test whenever you all want to find out. But after Bolitho has come into play, it is left to the judiciary to decide if they should take the judgment on the board or not. So ultimately, it all boils down to what the judge feels, who is right, who is not. If you have such discouraging, judgments from two boards.
Sir, in the same continuation, you must be knowing there is a recent case of one post-operative death of a child. So in that, the one board gave different opinion and held the doctors guilty. So why this should happen? I mean, this one board has acquitted.
The fault is with our boards then somewhere. Definitely the fault is with our boards, because see, you cannot say purely boards. See, the boards go according, both the parties are called and this. So therefore, the documentation is extremely important. If your documents are proper, definitely the board will give you the proper judgment. If we are unfortunate it is, but even today after so much of such medical legal conferences and all, we are still so reluctant to write our daily notes and everything in detail. We leave it to either a registrar or to that assistant or someone to write, and that is where we land up with problem. Even simple things like taking consent for a surgery, we don't take it on our own. Though that's why in my lectures I always say that the surgeon should be the last one to sign on that form before everything is filled. Dr. Kadam will agree with me, there have been so many cases in the council where only the patient's name is written by the sister on top and the signature of the patient is taken down. There is nothing in between, not even what surgery, what complications, nothing is written. So that is inexcusable, I feel, in today's era. Old era that used to be accepted, but not in today's era.
My last question to Jay sir and SP sir is that one young girl is coming with pain in abdomen and vomitings. In the middle of the night, she is accompanied by the neighbor. She is admitted to the hospital. In the due course of 6 hours, she has been deteriorated. When our doctor calls to that neighbor who has accompanied the patient's condition is deteriorating. The neighbor, so-called neighbor, ran away from the hospital. In another 2 hours, patient is gone on the ventilator. We are calling the patient, doctors are calling the hospital and calling the relatives. And next 4 hours, the patient died. But when it has the neighbor or accompanying relative, so-called, ran away, doctor informed this thing to the police station. The day police should register offense against the doctors. The police didn't interrogate at that time. Police registered the case. The case is been there in the court for 2-3 years. Again, after 3 years of mental torture for the doctor, the case is been dismissed. Therefore, whether the police is at fault, whether the doctor is at fault, and what we should expect from the judiciary.
Again, the answer is very clear. In such cases where there has been no malified intention or there is no malified act on the part of doctors, they should not be named in the FIR itself unless until some board recommendation is there or the report is there. They should not be named in the FIR, and generally it does not happen like that. Generally, doctors are not named even if relatives of the family comes with those complaints. We do not take the names of doctors in the FIR or the hospital administration. But even if in as pure talking purely on the legal perspective, if the FIR complainant is coming in the FIR, we have to take it. This is the kind of requirement from the legal side, CRPC requirement. Whatever is the complaint, we should register it unless if there is some exception to it. But it will happen in the investigation also that the names will be omitted out. There are provisions in the CRPC itself to omit those names which are not actually involved and they are not part of the charge sheet. We have provisions like section 169 and all, where those accused or the suspects which are not part of the criminal act, they are taken out from the charge sheet, they are not part of the charge sheet, and accordingly we submit the charge sheet. So in investigation also we can do that.
Sheet is filed into the matter. Filing of the charge sheet means that a criminal offence has been reported to the concerned police station, it has been investigated, and after collecting the evidence, the matter has been placed before the court for its scrutiny. As regards the procedural aspect, time required for conclusion of the trial of 2 hours, 2 years or 3 years, that is going on due to the procedural aspect. If after procedural aspect completed and after a scrutiny of the evidence, if ultimately it is found that there is no case of negligence has been made out, then ultimate result in the case will be that accused will be acquitted. Then whether the process till the filing of the charge sheet has been dealt with properly or who is at fault in that regard, that cannot be the part of a judgment delivery system. For that, the only remedy available is that if the complainant think that he has been maliciously prosecuted and there was no case of criminal nature made out against him, then he can file the case for damages by filing the case for malicious prosecution.
Can that doctor take the police officer to the court?
Yes, they can. Sir has, I think, already answered that you can actually file for the damages. That can be done.
Against the police officer.
Yes, who is responsible for malicious prosecution?
Thank you, sir.
We are end of this session. I think with a great applause, first of all, by the presence of sir has given to the IMA Nanded. Sir, with the gratitude and immense heartfelt thanks, sir. Jagirdar sir and Sikchi sir.
I have a certain concern regarding all the doctors from IMA Nanded that a majority of the times police do respond. But some MLCs and some cases the police don't respond timely, specifically deaths and specifically where a wrath of the relatives are there. So I kindly request SP sir to do something so that at least a police person take charge of the scenario and situation over there. It do definitely happens in the government hospitals, but in private hospitals, the burnt and crux of the wrath of the relatives goes directly to single person, and that should be avoided. Even if we do have task force, we cannot take the law in hand to do or counteract this. So it is kind request that take something action regarding this chat. So as Madam has told in some IT manner, but I say it in physical manner that somebody should come to us. At least a home guard should come to our hospitals to safeguard us. Thank you.
It should be like that.
So with this, the IMA President, Dr. Kotkar, we as a IMA family member are thankful to you for conducting this two-day session. Secretary Dr. Rahul Davekar and entire team of the IMA Nanded who are sincerely working since last 1.5 days. And with this, I conclude the session and hand over.